minutes. We have no other testifiers. We did have one that was withdrawn, but you have 15 minutes. Mr. Gosh, begin your testimony. State your full name and state your testimony, please.
Thank you, Mr. Chair, members of the committee. I'm Rob Doar. I'm the Vice President of the Minnesota Gun Owners Caucus. I won't repeat, kind of what precipitated this bill, but Justice Thiessen was right that the decision in his dissent, the Blevins decision, flies in the face of human nature. With the latest iteration of the duty to retreat from the higher courts, it places this unthinkable burden that before even presenting counterforce, somebody must seek retreat. And instinctively, if somebody was to try to throw a punch in your face, you're going to put your hands up. You're going to try to find some counterforce to the threat that's facing you. And this decision says, now you have to retreat before even evaluating that counterforce. Minnesota's self-defense law is a mess. The duty to retreat is not something that this body has ever passed. It's something that's been created and further confused by the judicial branch. It first appears in 1967 with State versus Johnson. That had to do with whether reluctant participant includes a duty to retreat. That was further clarified what constitutes a reluctant participant in State versus Baker. State versus Basting in 1997 actually firmly laid out the 4 elements for the use of force, which included duty to retreat. But then the question was, well, do you have to retreat in your own home? Does the duty to retreat exist in your own home? That was in 1997 with State versus Pendleton. Then the question was, well, what about common areas of an apartment building? Is that somewhere where you have the duty to retreat? And that was in State versus Hicks in 1998. Then the question was, well, what about the hallway of an apartment building? Does that constitute somewhere where you need your duty to retreat? That's going to be answered in State versus Devens from, 2014. And then how serious does the threat have to be before you need to retreat? That'd be State versus Carruthers in 1999. And then what if the co-aggressor lives with you? Do you have a duty to retreat if the person actually lives with you? That's State versus Glowacki in 2001. And then there's more and more and more cases that all surround the duty to retreat in Minnesota. So in order to have a comprehensive understanding of when and when not you have the right to use self-defense, you have to understand a mountain of case law relevant to your situation. You have to analyze that in the microsecond that you have to decide whether you can present deadly force or whether you're obligated to retreat in that situation. I don't think this is a workable situation, and whether it's with Representative Bliss's bill or another bill, it's long past time that the legislature clarify what the elements are for the right to use deadly force in self-defense, but this also doesn't just include deadly force. It doesn't only include firearms. It's if you're using your vehicle in order to try to avoid an aggressor, or a machete, as was the case in this. In some instances, it could be argued that less than lethal weapons could still constitute deadly force. It's time for the confusion to end and for the legislature to make it very clear to peaceable, law-abiding Minnesotans what has to happen in order for them to lawfully use deadly force without needing to read dozens of case law in order to understand it. Thank you.
Thank you. Next testifier, Mr. Gosh,